life. This is the case going on in the Supreme Court. The government says that the Supreme Court has to differentiate between the basis of conviction, basis of disqualification, and the effect of disqualification. In the criminal law, the effect of any kind of conviction lasts only up till the sentence lasts. How can the sentence's effect be longer than the sentence itself? That means if a tainted politician, if a convicted politician is convicted for just 6 years, how can the effect of that conviction be longer than the conviction itself in the form of disqualification on contesting elections? This is the first news article that we are going to talk about in today's news analysis. Then, South's share in the seats in Lok Sabha will not be affected with the delimitation exercise. This is what the Home Minister says. I ask you a question at the outset. Under whose jurisdiction the Delimitation Act comes? Delimitation of constituencies is to be done after every census, but there was a freeze that was imposed on the number of Lok Sabha seats to be revised after every decennial census, right? So the number of seats were frozen so that the states that are able to control population, they are not affected in the guise of revision of seats. UP, Bihar, Madhya Pradesh, Rajasthan, the states with increasing population will get additional share in the Lok Sabha seat pie if the seats are revised according to the latest census. But here comes our Home Minister, who is assuaging, who is in a way addressing the concerns of the state legislative assemblies, state governments, especially the southern states, that your interest will be taken care of in the latest delimitation exercise. Right, so these things are there. I hope audio, video, everything is working fine. Then government opposes plea to ban politicians for life. Let's talk about Rinki Aake Papa, not the other one, the song one, but the Panchayat series. Here, the Supreme Court had appointed a panel, a select committee, whereby the select committee was required to advise the government as to how to restrict the phenomena of Sarpanch Pati. Even though 21 states and 2 union territories implement 50% of reservation for these women candidates, but we see a phenomena whereby proxy candidate, the Sarpanch Pati, the husband, due to patriarchal nature of Indian society, comes to the fore and takes all the decisions in the name of his wife. So the patriarchal society and the reform of our legislative bodies or governance bodies like Panchayati Raj institutions. Today we are also going to talk about Naksha scheme, a scheme to have well curated maps for urban areas having a population below 2 lakh. So that Naksha scheme is going to be implemented by Department of Rural Governance. Okay, so we are going to talk about that. Then Section 9 of Persons with Disabilities Act 2016. Okay, how is it in conflict with the right to privacy? Why can't the disabled person decide for itself when it comes to the online arena, like using Paytm app, like using Google app, or for that matter Facebook, YouTube, any other social media application? So this issue has been lingering on. Why are persons with disabilities worried about the DPDP rules? Digital Privacy Data Protection Act that was enacted in 2023. Under it, the rules have been promulgated by the Ministry of Electronics and Information and Technology. So guys, these are the news articles one by one we will deal with. Before we begin, let me tell you, we are organizing at PW world's biggest educational festival, okay, in the form of Vishwas Divas. Now, if you ask me what do we mean by Vishwas Divas, to strengthen the bond between the teachers and the students, okay, to take it to next level. We are in an age where so many YouTube channels, so many educational platforms have come up and have, taken the educational level, especially through the online platforms, to the next level. But since PW is leading in that race, in that competition, So we are organizing this on 28th of February on Alag Sir's channel, Alag Sir's YouTube channel. Link and everything is given in the description. We want to see all of you, and the reason is for you also there is going to be a benefit. There are going to be surprises for every category, including the UPSC category, judiciary, NEET, etc. All the categories that PW Physics Wala is running. Okay, so 6 p.m. 28th of February. Mark your calendar accordingly. We wish to see you all there for your surprises. Plus, there is an emotional angle to it, to connect, to strengthen the bond, as I said. Okay, so rarely does it happen in this online arena that many edtech platforms, they have come up, they have vanished, but never thought of organizing such kind of a festival. Okay, so I have been associated with a lot of platforms. I advised one of the platform CEO also to do some such kind of a thing way back in 2019, but then they were busy with something else. Now coming back here, so these things are there. Panel seeks penalties to end proxy rule. Okay, proxy rule by male relative of the women candidates. One by one, 73rd Amendment Act mandated 33% reservation for the women, but there are many states and UTs which have taken it to 50%. That means under the Panchayati Raj Amendment Act, 33% reservation was required, but many states amended their Panchayati Raj Institutions Act and mandated 50% reservation. Even though today around 46%, more than 46% of the candidates, the elected representatives are women at the Panchayati Raj bodies level. Okay, but the problem that is happening is the real empowerment here is lacking. Real empowerment, you understand? Pati, the husband, is taking, or the brother is taking the decision. So that means the Panchayati Raj institutions are co-opted by the non-elected yet relative of the elected representative. Here, women. We have seen that wherever women have become the elected representatives, there the separate toilets for the girl children in the schools. Okay, their distribution of sanitary napkins for menstruation, those issues have happened. Positivity, progressivity of women has been witnessed, but the overshadowing of the women elected representative by her husband, by her male relative, be it any of them, brother, cousin, or they were brother-in-law, etc., etc. Okay, that issue is affecting our rural governance landscape insofar as women are not allowed to come to the fore. While this news clipping does not go into the reasons, I have incorporated a small reason here. See, the problem is the constituencies, be it for the Panchayati Raj constituencies, are reserved on a rotational basis for 1 year term of 5 years. In some states, 2-year term of 10 years, 5 years each, right? After the rotation is gone, the pati again, the husband again comes to the fore. Husband is the real contestant in whose name wife is contesting, in whose place wife is contesting. So this patriarchal mindset whereby previously male members of society will only contest the positions of panch or sarpanch and women would not be allowed to participate at all. Now that the constitutionally mandated, legally mandated reservation for women is there, women are mere figureheads. Okay, figurehead means they are just a face of it, the facade of it, but the actual person taking decisions from the behind is the husband, the brother, or any male member. All right, so what to do if we cease this rotation? Why do we have to have rotation? Seats cannot be reserved eternally for one section of society. That will be against the spirit of Article 14, right to equality. Then male members would say, why can't we be allowed to contest from, let's say, village, any village, okay, village 1. So if male members would not be allowed to contest from village 1 for till eternity, let's say for 20 years at a stretch, reserving that seat in village 1 for women only, that will be against the spirit of Article 14. So that is why the seats have to be rotated every 5 years or every 10 years max. Otherwise, it will be challenged in the Supreme Court on the pretext of violation of right to equality. Article 15 enables the government for carving out some special provisions for the betterment of women and children. Okay, but that cannot be eternal. other candidates should also have the right to contest elections from that same constituency. And that is the reason the seats are to be rotated. That is why the husband feels that his wife is only for 5 years, so he needs to somehow maintain his vote bank just by overshadowing his wife, as is depicted in this picture also. This picture was there in the beginning. Okay, so you can see husband thinks that Rinkia ki mummy does not have any sense, right? She cannot decide for the rural local bodies, right? So what do you know? This dialogue is this phrase is repeated n number of times in this series also, Amazon Prime series. If anyone has watched it already, no need to watch it for the purpose of this topic. The simple point is, in the other day's news analysis, we talked about Panchayat devolution index. So back to back 2 news articles are appearing. This is how you can correlate your notes. Okay, so women elected to local government positions are often reduced to figureheads, with male counterparts, with their male relatives making actual decisions. So what has the committee said? A committee was appointed by the Supreme Court, sensing the gravity of this problem, that even though despite the constitutionally mandated provision since 1992, women are not coming to the fore. Women are not coming to the forefront. So what do we do in that sense? Okay, the court appointed committee was there. The committee said that strict penal provisions can be there to put the proxy candidates, to put the proxy decision makers, husbands, in place of their wives taking decisions. Okay, so they can be put behind the bars, they can be disqualified for till life. And the panel also suggested that there can be the matriculation or 12th standard pass as the educational criteria for women candidates to contest. Okay, this kind of a feedback, this kind of a suggestion was given by various state governments, that if women would be literate, educated, they would be in a better position to actually take the decisions in place of their husbands. So this suggestion has not been incorporated in the final report of this committee that was appointed by the Supreme Court. Okay, so they proposed a multi-pronged strategy. Okay, 4-pronged, 5-pronged strategy: policy intervention, structural reforms, technology solutions. So that means any husband should not be allowed in the vicinity of the Panchayat Bhavan where the decisions are actually being taken. If the husband is not the elected representative, he cannot roam around. So those kind of solutions have also been given. Then gender exclusive quotas in Panchayat subject committees. So that means if there is a Panchayat committee on women issues, so gender exclusive quotas will be there. No male member will be allowed in that. So that means this will be the sole preserve of the women representatives of that area, to the exclusion of all the male members of the village. So this can be one of the things. Public swearing in ceremonies for women pradhans in Gram Sabha. So this public swearing in will mean that the women representative will take the oath, swearing in that she would be the only one taking the decisions. She will not allow anybody else, including her husband or any male member of her family, to interfere in the actual decision making process. These kind of public swearing in ceremonies will have 2 effects: ceremonial, publicly declaring the women to be the actual representative, whereby she will gain that confidence that is required of her, that is required from her to actually run that rural local body. Okay, you understand the importance of demonstration. If somebody is taking oath right in front of the village area, whatever taboos are there, whatever social stigma is there, that gets demolished there itself. So that women is actually taking the decision. No facade in the form of ghungat, etc. would be allowed to come in the way of her actually performing the duties. Right? I hope you understand the metaphorical sense what I am trying to explain. These taboos have for long held back the women from these rural local bodies. Even though they are elected, they are represented, but they are not allowed to perform the actual duties. Now, establishment of helplines. Wherever a woman feels that her husband is overpowering her or overshadowing her, women watchdog committees can be there, helplines can be there to help the women. So that can be one of the ways. Whistleblower rewards can be there. Wherever any village commoner, any village resident comes up with the highlighting the issue by recording with the camera that women is not taking the decision, pati sarpanch is sitting in the meeting of the village sarpanches, those type of video footages will be rewarded. Those type of whistleblowers who actually highlight the issue in a particular village, even those people would be rewarded with some benefit, with some reward, so that these proxy candidates are fearful of the janta, of the the voters getting aware about their rights, and they might highlight it to DM or any other functionary in the rural local bodies, ministry or Ministry of Rural Local Bodies in a state can be one of them. Okay, exemplary penalties for proven cases of proxy leadership. See, there are certain problems of social issues emanating from GS Mains Paper 1, for which even if we try to find out the legal solutions, like we are trying in this case, what are we trying to do? We are trying to legally solve a problem which is etched in the mindset, which is etched in the Indian society. Can you erase a problem by giving penalties? Why would a sarpanch be fearful of taking decisions because of the allurement of ability to contest next elections? Okay, so that means he is ultimately going to contest elections. There are so many FIRs pending, so many criminal cases are pending. Can this issue of a sarpanch being punished, a male sarpanch being punished, or male husband, the husband of the female sarpanch being punished, will be a deterrent effect? No, not at all. There are murder cases pending. That is our next issue of analysis today. So this will not be a deterrent. This will be rather another qualification in the next election, whereby husband would say, my wife was overshadowing you guys. She was not able to understand the problem of the village. So I had to take a step. I had to take a decision to actually sit in that meeting of the village sarpanches and take decisions for you, for which I have been labeled as a criminal or anything, right? So this is not going to be a deterrent, having a deterrent effect. So what is the solution here? Solution is education can be there. Can there be empowerment without education? Okay, Haryana, it came up with the 10th matriculation as the requirement for contesting rural local bodies election. Can education be the only empowerer? You getting my point? Is there any other way to empower people, empower women, especially in the context of this news? Yes, right. It doesn't mean that only this thing will happen. Okay, so women communities, what can we have is, rather than having rotational sarpanches, we can have one seat reserved till eternity for all the panchayati raj bodies. That can be there, right? But 33% reservation is there. Despite that, this is not happening. What's the solution to it? Social empowerment will only lead to political empowerment, or political empowerment will lead to social empowerment. That's the dilemmatic question for the day. So here I have written one question: how to resolve the rotation dilemma. So if we rotate, for example, in year 2025, seat 1, in 2030, this seat will not be reserved anymore. Women or men can contest. Then 2030, this seat will be reserved, seat 2, women. Here, the women, whatever leadership skills she has gained, whatever you can say the recognition she has gained in this constituency 1, in this seat 1, that is lost the moment this seat is declared unreserved. Okay, there will be so many male members against whom she will be contesting. So that is the problem. We can reserve this seat for 2 terms, 5 years terms. Okay, so that can be one of the solutions. Then seat 2 is reserved for 2030, from 2030 to 2035. So this will be there. Next year, seat 3 will be reserved. This is the problem, that women are not actually able to elongate this phenomena of the good work that they are doing, or you can say prolong this phenomena. They are not able to become the permanent representatives. They are the temporary representatives. That is why the husband from behind the scenes is calling the shots. The husband is the ultimate decision maker in the Panchayati Raj institution, in which seats have been reserved as well. Moving on to the next topic. Okay, so there are no solutions. We can have social empowerment of women. whereby women communities are there, or you can say the shadow parliament kind of a thing is in the working at all the times. Shadow women parliament or shadow women panchayat, even though it is not elected, but it is a kind of self-help group which is going to petition the panchayat for all the women related issues. As we have seen in the financial arena, self-help groups have been of a great advantage insofar as implementation of women-oriented schemes are concerned, financial empowerment of women is concerned. So self-help groups, shadow cabinet or shadow sarpanch, shadow panchayat can be of great help over here in the sense of real empowerment of women candidates. Ministry of Parliamentary Affairs, state ministries of parliamentary affairs, they have been organizing the empowerment drives or training programs for the political empowerment of women. But real political empowerment will happen if it is allowed some kind of continuity, unlike the one envisaged by the temporary method of reservation of seats. Right. Now, moving further, Panchayat Devolution Index was the latest thing. Please answer in the comment section which is the state which has performed well, okay, at the top in this year's Panchayat Devolution Index. We had studied this topic day before yesterday only, so I think you should be able to answer this question quickly. Which is the state and what are the criteria? There were 6 parameters which we had studied. Okay, name at least 3 criteria that you can recollect from the previous day's discussion. Now, coming here, the panel has recorded that one of the suggestions we have covered all this. Now, this is the related PYQ. Quickly, MCQ, quickly answer this. Moving further. So here, very nice line given by the Attorney General. The case is, should convicted politicians, once a criminal, always a criminal, should convicted politicians be banned for lifetime? Okay, can we ban the convicted politicians for lifetime? That is the question. The answer given by the government in the Supreme Court is that government is not in favor of this. Central government is not in favor of this. Well, that is but obvious for any political party, any government that is having 42% of its sitting Lok Sabha MPs as criminals, having any charge or anything. I have explained this issue many a times in our previous classes also. So what did we see? We saw that, just allow me a moment. We saw that accused is labeled as convict once the charges are proven in the court of law. Okay. Then we saw Lily Thomas case, that in Lily Thomas case, no 6 months time period is going to be given to a tainted politician to appeal against the order. So if, let's say, a sessions judge, a sessions court convicts a tainted politician, earlier he used to get 6 months period to appeal in the High Court. Until this 6 months period, he will not be disqualified. This was the breather period between the sentence, period between the conviction, and 6 months for appeal in the High Court. Right? So this was the problem. This gap was deleted by the Supreme Court by its Lily Thomas judgment in 2013, whereby the Supreme Court said that the moment the conviction happens, immediately the convicted politician would stand disqualified. Okay, no breather of 6 months will be given to enable him to appeal in the High Court. Agreed, sir. Now the problem is, once a criminal, always a criminal. Is it right? Is it not against the principles of natural justice? Yes, it is. Okay, so principles of natural justice says that there is a doctrine of proportionality. That means the punishment that you are meting out to, giving to some tainted politician or some ordinary criminal should be in proportion to the crime committed. That means for killing an ant, you cannot give elephantine kind of punishment. Okay, for killing an ant, the punishment cannot be of the size of elephant. Agreed? Ant elephant kind of analogy, understand? So principles of natural justice are there. They beg that principle of proportionality should be there. Article 14, Article 20, etc. Now, just because somebody is a politician, is it right to ruin his career simply because he is a politician, right? That too when the known cases of political vendetta, known cases, that means taking revenge. If Kejriwal is in power, he will put somebody else, one or the other person in the jail, okay, or political opponents in the jail. If talk about J. Jayalalitha and M. Karunanidhi of Tamil Nadu. When Jayalalitha would be in power, the premises of M. Karunanidhi, DMK leader, would be raided. Police will raid and pick him up in the dead of the night. Same happened with J. Jayalalitha also. The premises of J. Jayalalitha madam would be raided once the opposition party comes to power. So that has been happening in the political landscape everywhere. In such an atmosphere, you say that just because someone is convicted by the sessions court, when the judiciary is not transparent, when there is corruption, allegations of nepotism, allegation of favoritism in the judiciary, can you declare somebody as a convict for his lifetime? That too when the pace of judicial proceedings is very slow, tariq pe tariq, date on date, right? So that is the problem here. Now the very nice line that can be reproduced in your mains exam also is the petition filed in the court to convict, to ban the convicted politicians for lifetime, the government says is illogical, as it seeks not to differentiate between the basis of conviction and the effect of conviction. Basis of conviction is crime. Once the conviction ends, the effect of conviction should also end. Effect of conviction cannot be the lifetime ban on the politician, right? So here is the basis of conviction. What is the basis of conviction? Somebody is convicted because he or she convicted a crime, so for which he was given the punishment for, let's say, 20 years life imprisonment or 10 years, whatever. Then the effect of conviction should be commensurate or should correspond to, effect of conviction should correspond to the term of conviction, right? How can the effect of conviction be longer, be long lasting, or be longer than the term of conviction? Lifetime ban. Principle of proportionality gets violated here. And then the government says that this is the preserve of the parliament to amend section 8. This is one argument by the government. Second argument by the government is, if the court would go on, if the court would muster the courage to ban the politicians for lifetime, court is actually amending section 8 of Representation of People's Act 1951. What does this say? Section 8 of 1951 Representation of People's Act says that, it says that if a term of the punishment, term of the sentence is more than 2 years, okay, it has to be 2 plus years, 2 years or more than 2 years, then there will be an additional ban for 6 years. That means the term ended. Already we have a deterrent that if you commit a crime, you are a politician, you would not be allowed to contest the elections for until lapse of another 6 years, additional 6 years. Now taking it to beyond 6 years is the job of the parliament to amend it. This is what the government is saying, job of the parliament to amend it. How can the court amend it, right? Court has taken several baby steps in the form of introducing nota, right? Let us talk about the past reforms also. Court has introduced nota, none of the above. If I as an electorate, if I as a voter do not like any of the candidates, candidate A is corrupt, candidate B is even more corrupt, I do not like both of them, I can choose nota option. Then court said that any candidate being nominated by a political party, within 48 hours of his nomination, his criminal antecedents have to be published in the, whatever his qualification is, his criminal antecedents have to be published in the national newspaper. so that voters are made aware of the credentials of the candidate. Okay, these are the several strictures, directives that court has given to the political parties. This is the theory that has appeared in today's newspaper. Let me link it to, this is the background that I've given you so far. What is the status? How the politicians who are convicted are treated. They are banned for 6 years additional, in addition to their sentence term. If the term is for 7 years, 7 plus 6. If the term is for 2 years minimum, then only this additional 6 years ban would kick in. Done. Here, nomination, right after the nomination, within 48 hours, the criminal antecedents, how many FIRs are pending against him, all this has to be published. Agreed, sir. Now, what do we do? The problem is political parties are least regulated through our constitution. Okay, the only reference we find to political parties is in 52nd Constitutional Amendment Act, that is the 10th schedule about anti-defection law. The problem of India at this time is the political parties which regulate the conduct of elected representatives of the people are themselves not regulated. Right, even as the cat is regulating all the rats, but there is no bell in the neck of the cat. Cat here being political parties. Political parties can spend an amount of crores of rupees in winning the elections. Political parties can get the donations from foreign companies also, Amazon, Walmart, etc. Political parties can make the tainted politicians, can make the convicted politicians contest elections and still claim to be neat and clean. So that is the problem. Okay. Now moving further, domain of the parliament. These are the arguments in today's news clipping. Why they are important? Let us see what the court comes up with. Does the court have any argument? There are so many eminent lawyers who are acting as amicus curiae in this case. Okay. So Mr. Upadhyay, these names are there. And then Association for Democratic Reforms, the not-for-profit organization, NGOs, they are associated in cleansing the political landscape of India. Until and unless we do not have cleanliness in politics, there will be no cleanliness, no Swachh Bharat in other arenas of public life. Now, moving further, distinction between the basis of disqualification and the effects of disqualification. This is, I have explained you the crux of it. South's share of Lok Sabha seats will not be affected by delimitation. Home Minister. Now, I ask you a question to the students, not to the Home Minister. So, which is the ministry that implements Delimitation Act? Okay. So, southern states have many grouses. One of them is they are the major contributors to the GST, the economy of India, and yet they get the lesser share in the Finance Commission grants. Even though GST and Finance Commission, they do not have much of the correlation, but still, okay, then they are the major contributors to controlling population control in India, yet they are given the lesser number of seats in the Lok Sabha. If the President of India is elected, the President of India is more of the northern states of India, as Planning Commission called them Bimaru states, Bihar, Madhya Pradesh, Rajasthan, Uttar Pradesh, okay, because of their exceeding population. Now, southern states will be at a disadvantage if the seats are allocated, if the seats are delimited or revised on the basis of the latest census, if ever conducted. Conduct of census is itself an issue, right? So government has been dragging its feet on conducting the census. However, if the seats are allotted or revised or reallocated on the basis of 1971 census, or on the basis of 2011 census, what will be the ratio of seats that will be allotted to what will be the ratio of seats, number of seats that will be allotted to Kerala, Tamil Nadu, Andhra Pradesh, Telangana? This is the concern. To assuage their concern, Home Minister himself says that share of the southern states of India will not be reduced. It will be proportionately maintained. On one hand, we say that India is the country which is least represented, in the sense that one member of parliament is representing around 2 million people. 20 lakh, more than 20 lakh people in certain cases. So one member of parliament, 1 is to 2 million is the ratio. We need to revise the number of seats. Okay. Law Commission and various other commissions, they have said that the Commission for Electoral Reforms also, they have said that we should increase the number of seats as per the German system, list system, or the number of seats should be at least 726 in Lok Sabha. These have been the recommendations by various commissions and committees. Now, another issue is in Lok Sabha also we follow the principle of representation of seats on the basis of population. Same is the case in Rajya Sabha. Unlike in the US, where the seats, 2 seats are given to each of the 50 states, 50 federating units in one of the houses. Okay, in the Council of States at least. So in Rajya Sabha, the criteria for representation should be principle of equality rather than the principle of proportionality. We allocate the seats to the states on the basis of population in proportion to their population in Lok Sabha. So why copy paste that phenomena of allocating the seats on the basis of population in Rajya Sabha also? This is one of the other reforms that is required. Okay, so these things are there. Union Home Minister said that the southern states would not lose even a single seat after delimitation, addressing the long held apprehension of the states such as Tamil Nadu and Kerala that they would stand to lose. These southern states would stand to lose in terms of their political representation. Let me tell you, the value of vote of the MP from UP was around 400 in the latest presidential election as per 1971 census, if the seats are allotted. Okay, well, the value of vote of an MP from Tamil Nadu was 208. An MLA from Tamil Nadu was 208 and an MLA of UP Legislative Assembly had 408 as the value of vote of an MLA from Tamil Nadu. That being the case, the president is already more of the North Indian states than of the South Indian states. The principle of uniformity of representation of all the states in the matter of presidential election in the political say that they have is already less for the South Indian states. So that is another problem where South Indian states are on the receiving end. Then I told you that GST, Finance Commission, is always petitioned. Whenever the Finance Commission is appointed, it is petitioned by the southern states that even though they contribute more towards the GDP of India, but they are receiving lesser share out of the pie of the budget. Why? Because they are not as politically strong, as much represented politically in the Lok Sabha and Rajya Sabha as their North Indian counterparts. Take for example, UP has 81 seats, 80 odd seats in Lok Sabha, members of parliament, then 20 plus seats in Rajya Sabha. Compare this to Tamil Nadu, Kerala, Telangana, Andhra Pradesh. That is the problem of political representation, right? Now, another important issue of today's news analysis is persons with disabilities, section 9. Section 9 says that data fiduciary like Facebook, Paytm, Google, okay, will not consider the consent by a person with disability until and unless that consent is given by the representative, by the court appointed guardian of the disabled person. So persons with disability have got a concern that some of the aspects of the new regulations under the act, let me tell you what is happening. Okay, we have 2016 Disability Act. Okay, under this 2016 Act, what is happening is, under this Act, rules have now been drafted by Ministry of Electronics and Information and Technology for DPDP Act. Okay, Digital Privacy Data Protection Act of India, enacted in 2023, says that under section, this rules now say that under section 9 clause 1, a person with disability will be represented by a guardian. This news had appeared in the last week also, wherein we had studied that this is leading to in a way treating the persons with disabilities like adolescents. Okay, we treat adolescents in the manner that they cannot watch any adult film, etc., or they cannot create a Facebook account without the consent of their parents. This is how we treat them. Okay, parents consent is required. OTP verification from the parents mobile number, undertaking that they are over the age of 18 years, those kind of things are required. Do we require the similar kind of a treatment for person with disability? When he wants to create a Facebook account or Insta account, he needs to have the consent of guardian. Okay, so this is like infantization of persons with disabilities. These terms are important when you write your mains examination. Okay, infantization. So rules drafted under the Persons with Disabilities Act of India 2016 are not in sync with United Nations Convention on Rights of Persons with Disability, PD rather. Okay, United Nations Convention on Rights of Persons with Disabilities. Some of the aspects are not in sync with it. Then let's talk about the National Trust for Persons with Cerebral Palsy, autism. Okay, there also some of the we have incorporated a table also here. This will tell you what are we talking about. One act is this. Okay, here limited guardianship is given to the person themselves, disabled person themselves, they have limited guardianship. On the other hand, we have some more set of laws and regulations which govern the persons with disabilities suffering from autism, cerebral palsy, etc. So National Trust for Welfare of Persons with Autism, Cerebral Palsy, Mental Retardation and Multiple Disabilities Act 1999. Under this act, it applies to individuals with autism, etc. Okay, with due respect, it provides for full guardianship. Here, full guardianship will be given to the custodian, to the guardian appointed by the court. Okay, he will be the one to use the decision making capacity. Got it? Under this act, the guardian so appointed will be in full capacity to use the disabled person's decision making capacity. But here, limited guardianship is given. When we talk about rules, rules say that under section 9, the person will not be able to decide for himself as to what does he want to do on Facebook, etc. Whether his Facebook account can be managed by himself or not. Whether he can transfer money through Paytm or any other UPI application or not. All these matters are going to be decided as per the rules by the guardian who would be appointed. Okay. Then there are strictures. Lack of clarity is not there. Unlike the detailed illustrations provided for the child consent, the consent of the child, we were talking about parent-child relationship. The rules lack similar examples for persons with disability guardian consent. Okay, for person with disability, such kind of illustrations as are given for any other child consent, child parent consent relationship, they are not as demonstrative, as illustrative as for children. Okay, so for the PWDs, they are not as detailed. Concerns from the activists, disability rights activists and experts are questioning how the consent clause will apply to various disabilities, severity levels and guardians appointed under the different laws. So there are two laws. There is lack of clarity for person with, let's say, 60% mental incapacitation or mental retardation. Will the same rules apply? Will the same set of strictures apply for somebody who is mentally retarded up to 30%? Right? You cannot carte blanche, you cannot paint every disabled with the same brush. You cannot treat the disabled, with due respect, the differently abled people treated under this law in the same manner and the disabled people declared under this law. Declaration 1, Declaration 2. Disabled declared under this law is more disabled in terms of percentage, if that could be assigned. Okay, not to remind you of Pooja Khedkar here, we are talking about the serious case if somebody is mentally retarded, incapacitated for up to 70%. For him, the guardian should get more rights. But if somebody is mentally incapacitated for up to 30%, he should be given more authority to decide for himself or herself, right? Then the right for disabled people, women disabled. Then another problem is we have under the rights of persons with disability, under the right to education, we have norms like there should be ramp ways. if the disabled people, handicapped people, they cannot climb up the stairs, for them there should be ramp ways. For ATMs, there should be audio visual thing, right? That even if a person is not able to see the buttons, if somebody is blind, because of the audio aid available in the ATM machine, sometimes you would have wondered why ATM machine is so loud. It is loud because some people are suffering from hearing impairment. For them, okay, some people are blind and only rely on the audio commands being given to them. That is why the sound system is there, right? But in the physical space, these type of norms are there. If you talk about the online space, can you say that Paytm is user friendly for disabled people? Can you say that Google Pay, Phone Pay, they are all riding on the popularity? They are all riding on the catering to their majority, okay, majority quotient as we call it. They are not catering to the minorities insofar as disabled people are concerned. So another concern of the disability activists is that the applications in the e-arena, app, you yourself is being replaced by, your app is being replaced by app. In this garb of digitization of payment system, digitization of anything you do, digital locker, etc., your certificates, your custodian of every single iota of your identity is the digital space. In that space, the disabled people are lagging behind, even more than in the previous regime of physical infrastructure. So digital infrastructure needs to be compliant with the Rights of Persons with Disability Act and United Nations Convention on Rights of Persons with Disability. This is what this entire thing that has appeared in the Hindu says, that some of the elements I have added from Times of India and other articles that were pending. Okay, so inaccessible digital platforms. Many commonly used apps and platforms, Swiggy, Zomato, Flipkart, have poor accessibility scores. So they have devised an index here. Accessibility scores are assigned to these applications. Okay, scores are not enough because they are earning crores. You're getting my point? Merely scores are not enough, sir. When Zomato's business is not going to be affected by these accessibility scores, because they are just interested in the ratings by the majority of the app users, the Ministry of Social Justice and Empowerment, which looks after these matters, needs to come up with some new criteria, some penal criteria, even though giving them a breather space of 1 year, 6 months, 1 year, 2 years, but they need to be compliant with the spirit of this act, not just the letter. Right? So this is how you can generate unique points for your mains examination. Guardian's right to opt out. These are the problematic areas. The essence we have understood. This was all in today's news analysis. Take your leave for the day. Thank you. It was a pleasure teaching you all. Please answer the questions. I'm not asking many questions. If you do not answer those questions even, it is demotivating for me as a teacher also, because I do not know if these are, this algorithm number, whatever people are watching, whatever little are watching, I'm not worried about that. What I'm worried about is we have to maintain the quality. We have to at the same time have a two-way road. That means you are also answering. If you are not answering, then it is not worth my effort also. This is all. Thank you. Take your leave. See you again tomorrow with another interesting set of articles and editorials. Thank you guys. Bye-bye.